New year, new innovations. If file a patent application made it onto your 2026 goal list, congratulations, you're thinking like a business owner who understands that intellectual property can be a serious asset. But if you're staring at that goal wondering what your first move should be, you're not alone. Patent law is complex. That's why I went to law school and took an additional bar exam for it. But the starting point doesn't have to be scary. Let me walk you through where to begin when you're ready to protect your brilliant idea. Step one, first things first, do you actually need a patent? Before you dive head first into the patent process, ask yourself, is a patent the right protection for what you've created? Patents protect inventions, new and useful processes, machines, manufacturers, compositions of matter, or improvements to these things. If you've invented a new guitar pedal that creates a sound effect nobody's ever heard before, that could be patent worthy. If you've designed a logo for your horror-themed coffee company, that's trademark territory, not patent. If you wrote a killer screenplay about vampires who run a patent law firm, actually, don't steal that. I might use it. But anyway, that's protected by copyright from the moment you write it down. Understanding what type of intellectual property protection you need is step one. Don't waste time and money pursuing the wrong kind of protection. Step two is document everything. Here's something that sounds obvious, but people mess this up constantly. Write down information about your invention in detail with dates. You don't need fancy legal language, but you do need a clear description of what your invention is, how it works, what problem it solves, who came up with which part if there's more than one person involved, when you came up with it, and any improvements or modifications you've made, and when you've made them. Think of it like an IMDb entry, the ones listing all the actors, the character names, writers, producers, costume designers, filming locations, trivia, and user reviews are the ones that give you the best information about the film or show and whether you might like it. Date your entries. If you're keeping a physical notebook, that's great. If you're using digital files, make sure they're backed up and time-stamped. Why does documenting your invention like this matter? Patent law operates on a first-to-file system in the U.S., but your documentation helps establish your invention timeline, which can be crucial if disputes arise, and it's incredibly helpful when you're working with a patent attorney like me to draft your application. Step three, do some preliminary research. Before you spend thousands of dollars on a professional patent search and application, do some basic homework. I'm not saying you should skip the professional search. You absolutely shouldn't. But a little DIY investigation can save you from pursuing something that's clearly not patentable and spending money on an unnecessary search. Search Google Patents at patents.google.com and the USPTO's patent database at uspto.gov for inventions similar to yours. Use different keywords and phrases. Look at what's already out there. For example, when Gibson filed for the patent for the humbucker pickup, which is U.S. patent number 2896491, filed June 22, 1955, it was designed by engineer Seth Lover. They weren't the first company to create electric guitar pickups. However, their design was different enough, specifically using two coils wired in a particular way to cancel out the electrical hum that plagued single-coil pickups. That made it patentable. Those original patent applied for humbuckers, get it? They buck the hum. Anyway, those original patent applied for humbuckers became legendary, helping create the iconic sounds of rock and blues. Your invention doesn't need to be something nobody's ever thought of before. It just needs to be new and non-obvious compared to what already exists. If you do find something very similar to your invention, you don't have to panic. And don't give up immediately. Talk to a patent attorney. There may be ways to narrow or modify your claims, or your invention may have features that make it distinct. Step four is think about your IP strategy holistically. I'm not going to get all woo-woo on you here. That's for my alter ego's work. I'm talking about looking at the bigger picture of IP protection. Many inventors don't realize that patent may not be their only protection, or even their best. Maybe you need trade secret protection for your manufacturing process or formula. Maybe you need a trademark to protect your product's brand name. Maybe you need a combination of multiple types of IP protection. For example, the formula for Coca-Cola has never been patented. It's protected as a trade secret, which can potentially last forever, as long as the secret is maintained. But Coca-Cola does have numerous patents on bottling technology, vending machines, and other innovations, design patents for the look of its bottles, plus countless trademarks. Your IP strategy should support your business goals. A patent attorney who also handles trademarks, trade secrets, and business law, again, like me, can help you see the bigger picture and know what to do with it. Good attorneys won't push you toward what isn't right for you. Online patent mills and people charging freakishly low prices to assist you don't care whether a patent is what's best for your unique circumstances and goals. Step 5 is understand your patent options. Not all patents are created equal. There are three main types. Utility patents protect how an invention works and what it does. These cover new processes, machines, articles of manufacture, or compositions of matter. This is probably what you think of when you hear patent. They last 20 years from the filing date of the earliest application. Now, design patents protect how an invention looks. It's ornamental design. Think of that unique shape of the Coca-Cola bottle, which has had multiple design patents over the years, including the design patent number 48160 granted in 1915. Design patents last 15 years from the date of grant for applications filed on or after May 13, 2015. Plant patents protect new and distinct plant varieties that are asexually produced. Unless you're creating new rose cultivars, you probably don't need this one. Most inventors need a utility patent, but some need both utility and design patents to fully protect their invention. Utility patent applications are where things get interesting. For utility patents, you have two filing options, provisional and non-provisional patent applications. Design and plant patents only have non-provisional patent applications. A provisional patent application is less formal and less expensive. It lets you establish an early filing date and use that patent pending status while you refine your invention, test the market, or raise money. You have 12 months from your provisional filing date to file a non-provisional application that claims priority to your provisional application. Now, that provisional application never gets examined by the USPTO. It's essentially a placeholder, but that placeholder can be golden if you need time to develop your product or find investors before committing to the full expense of a non-provisional application. A provisional application also never gets published by the USPTO, which means no one searching its patent database, Google Patents, or any worldwide database can find it. That means it doesn't put others on notice that you've claimed the invention. Unless there's another way examiners in the US and other countries can find out about your invention and its details easily, it will be hard to use your invention to stop other applications. Now, I need to stop for a minute to make something very clear. There is no such thing as a provisional patent. No such thing as a provisional patent. It is a provisional patent application, and it will never become a patent unless a non-provisional application that can claim its priority date is filed within that 12-month deadline. I see people all the time think filing a provisional patent application gives them a patent, and that's just not true, and it's a tragic thing to be misinformed about. So let's move on to something a little less tragic. A non-provisional patent application is the real deal. It gets examined by the USPTO and, if it's approved, does result in an issued patent. It is more expensive and requires more formality, but it's what ultimately gets you the patent protection. That said, a non-provisional application, like a provisional application, is also not a patent, and it doesn't give you enforceable rights. You only get enforceable patent rights if and when a patent is granted. Now, sometimes that allows you to enforce rights going back a bit to when the application was published, but absolutely no patent rights ever happen if the patent isn't granted. Many inventors start with a provisional application to lock in their filing date. Then they file the non-provisional application within that 12-month window. This is a legitimate strategy authorized by U.S. patent law, though some practitioners focus heavily on non-provisional filings from the start. The right choice for you depends on your specific situation, timeline, and budget. Step 6 is know what you're up against. It's a reality check. And I'm going to be blunt with you. Getting a patent is hard. The USPTO rejects most applications, often multiple times, before ultimately granting a patent, if they do grant the patent. You'll likely face at least one office action, which is USPTO speak for "we have problems with your application." Responding to office actions requires legal and technical skill. Applications that get granted quickly and with no refusals aren't necessarily good. When it's a DIY application that's had that happen, it usually means it's so specific it can easily be designed around by competitors, which makes it not worth much. The patent process also takes time, usually 2 to 3 years at least from filing to grant, even if everything goes completely smoothly. And it's not cheap. Having a budget of at least $25,000 just to get the U.S. patent is wise. A professional patentability search to see if it's even a good idea to file can run $1,000 to $3,000 or more. A properly drafted patent application, depending on complexity, can cost anywhere from $8,000 to $20,000 or more, plus USPTO filing fees. Then there are the costs of responding to the office actions and maintenance fees after your patent is granted. A freedom to operate search to see if your invention may be infringing on someone else's patent rights is usually at least $10,000, often much more. It will cost a lot to enforce your patent rights too if you get them. A good cease and desist letter is expensive, and patent lawsuits are some of the most expensive there are. That doesn't even cover international filing at all. Having a budget of at least $25,000 just to get the US patent is smart and realistic. And I'm not trying to scare you away. I'm trying to make sure you go into this with your eyes open, like walking into a horror movie, knowing full well there are going to be jump scares. If your invention has real commercial potential, the investment is absolutely worth it. Now, step 7 is hire a patent attorney. Yes, really. Can you file a patent application yourself? Legally, yes. Should you, though? Almost certainly not. Patent law is incredibly technical. The USPTO has special requirements for patent applications. The claims, which are the part of your patent that defines what's actually protected, must be written with precision. One wrong word can mean the difference between strong protection and worthless paper. Patent attorneys have technical backgrounds. I have a master's degree in computer science and have taken college engineering level physics classes, as well as legal training specifically in patent law. We have to take a special patent bar exam before we can be registered to practice before the USPTO. We know how to draft claims that will hold up in court if you ever need to enforce your patent. We know how to respond to office actions. We know the strategies for getting your application through examination. Think of it this way. You wouldn't record an album without someone who understands sound engineering and expect it to make the charts. And you wouldn't create practical effects for a horror film without someone who knows how to make fake blood look realistic. I mean, you could, and some people do, but think about what those results are like. There isn't a fun market for useless patents the way there is an audience that enjoys horror movies with terrible special effects, in part because the effects are awful. Patents are our craft. If you just want a cool thing to hang on your wall and don't care much if you never get a patent, then DIY is fine. But if you're serious about your invention and having strong patent rights, hire a patent attorney to help you. If you're ready to take action, if filing a patent is truly your goal this year, here's your action plan. Make sure it's a patent you need, not trademark or copyright registration. Document your invention thoroughly. Do preliminary research to understand the landscape. Think about whether a patent is the right protection or whether protecting it as a trade secret would be better, and you can ask an IP attorney to help you figure this out. Know which type of patent applications you need, utility, design, and/or plant, and provisional versus non-provisional. Set aside a budget for the process and be realistic about costs. And then find a patent attorney you trust and can work with. That last point is crucial. You need someone who will listen to your goals, explain things in plain English, and guide you through a lengthy and complex process. You need someone with the right technical and legal chops to do it right, but also someone you actually want to talk to and aren't afraid to ask questions. Don't work with someone who gets uptight when you ask them to explain patent concepts to them. It's your right to know what's going on with your patent application and to understand the steps that are involved and what comes next. You need someone who gets that patents aren't just legal documents and knows they're tools to help your business grow and become more valuable. Someone who understands that behind every patent application is a real person with a dream and a deadline. Now, if that sounds like the kind of help you need, let's talk. You can reach out through my website at kingpatentlaw.com. I'd love to hear about your invention and help you figure out how best to protect it while achieving your goals, even if that's not working with me. I know other patent attorneys in other areas I can refer to, and I will tell you truthfully if I don't think getting a patent is your best way to go forward. Now go forth and innovate. Avoid the legal horrors and keep rocking your IP. I'm Julie King with King Patent Law. Thank you for watching, and I'll see you in the next episode. This information is for educational purposes only, is not legal advice, and does not form an attorney-client relationship. For advice about your specific situation, consult with a licensed attorney.